and legal system of East Africa, as we discussed in the previous lecture. We discussed on the different legal system in East Africa, the emergence of the legal system, and in today's lecture, we are going to discuss the bourgeoisie state legal system. This is simply the theoretical struggle against the feudal states. In this lecture, we are going to examine the new theory of the emergence of state that was prophesied during the transition period to capitalism. Let's start with the theory of state prior to capitalism. This theory, we are told, it prophesied that state and law are natural or eternal institutions. They are God-given. This is said according to the theory of state prior to capitalism. This theory was propounded by one of the very first scholars called Thomas Aquinas. Thomas Aquinas was of the view that since the church was the guardian of the eternal law of God, it had the unfettered right to interfere with the state, for it enjoyed unconditional sovereignty of the state. This is according to Thomas Aquinas, one of the very first theorists. We have another theory of social contract. This is among the very famous theories during the bourgeoisie legal system. This theory began to propound after the forces against the feudal order. This was the situation whereby the individuals wanted to free themselves from the church and the chains of feudalism. Slowly, as days goes by, it came a time whereby individuals raising commercial middle class. So this commercial middle class was started to be seen among the societies. As the emergence of this commercial middle classes, the need for freedom to pursue trade and time-needed protection were also a major concern among the societies. We continue with the theory of social contract, whereby the theory finds the source of political power in people, whereby this was the very first time where it was recognized the power of the people towards the governments. It sees the state as the legal creation of individuals which will not a divine power. So there comes a difference between a divine power and the law itself. This theory is an old formulation which was put forward by many of the medieval philosophers, as we have seen one of them in the previous discussion. So we are told that this theory received a lot of criticisms during the 17th century. But again, we have other scholars who were very forward to make sure that this theory works. Among these scholars, we have Grotius, Hobbes, Locke, Rousseau, and Montesquieu. These are very, very famous scholars so far as the social contract theory is concerned. Let's see these proponents of social contract. Let's see them one by one very briefly. Let's start by Hugo Grotius. Hugo Grotius was a Dutchman who was among the first exponents of the theory of the contract emergence of the state. He was of the view that people had the right to choose the type of government they want, or they see it is suitable for themselves. He also of the view that but once people have transferred their rights to the government or to the ruler, whether in order to find a protection against danger or because they preferred rule to liberty or as any other results of war, they forfeit their right to control or punish ruler, however bad this government might be. So Hugo Grotius was sometimes referred as the father of limited monarchy. He believed in limited monarchy of the government. Let's see Thomas Hobbes. As I said earlier, we're going to see them one by one very, very briefly. This was an English philosopher. He was also one of the founders of social contract theory, as I've said earlier. Thomas Hobbes believed that the state originates in contract by virtue of which each individual surrenders his sovereignty to the ruler. Hobbes believed that before the creation of the state, man was at war against all. That man was solitary, poor, nasty, brutish, and short. Due to all these causes, he believed that such situation precluding a normal life and threatening the very survival of a mankind. This being the case, according to Thomas Hobbes, to escape from this kind of situations, he believed that people needed to enter into a social contract that created state which was called upon to ensure the protection of the same individuals or peace in the society. So that is according to Thomas Hobbes. Let's see another philosopher, John Locke. John Locke is one of the famous philosophers. He was also an English philosopher. According to John Locke, his theory of social contract believes that he placed the individual in the center and invested him in the name of supreme ethical principles which inalienable natural rights, among which the rights of private property occupies a prominent place. So John Locke, as he differs from Thomas Hobbes, he believes that the state of nature was not one of anarchy, as Hobbes promulgated. He believes that this was all about peace, goodwill, mutual assistance, and preservation of the said society. So John Locke talks of property, protection of property, and which by this means he means that the individual natural inborn rights to life, liberty, and state. This is what John Locke means by when he referring the protection of people's property. So according to John Locke, is that the individual retained the natural right to life, liberty, and state, for they were the natural and inalienable rights of men. So this is according to John Locke, on as far as the social contract theory is concerned. Let's see another philosopher, Rousseau. This was a French philosopher, and he was also among the very first philosopher to propound on this social contract. According to Rousseau, he was of the view that men were originally free and equal, living with extreme simplicity in the forest according to the dictates of nature alone, in the so-called state of nature. So this is according to Rousseau. We are told that Rousseau was also of the view that man was not yet devastated by the degeneration or civilization. So this is what Rousseau believes insofar as social contract is concerned. Let's see another philosopher, Montesquieu, which is also one of the very famous philosophers insofar as the emergence of social contract theory. This was also a French philosopher. Montesquieu, in one of his writings, he observed that the natural effect of commerce is to bring peace. He saw Montesquieu advocated on the issue of development of economy and commerce. He believed that the spirit of commerce brings with it that economy, moderation, work, wisdom, tranquility, law, and order. So this is what Montesquieu believes insofar as social contract theory is concerned. I would say a bit on what Montesquieu contributions in this theory. It is said one of the great contributions of Montesquieu is the concern that division of power or separation of power into the government organs was one of the important issues or one of the major concerns insofar as his writings and his thinkings were concerned. So from the previous theories and thinkings from different philosophers, we get the connection to the principles of the Constitution. We have principles of the Constitution. Basically, we have like 4 principles of the Constitution. We have the doctrine of separation of power, we have the supremacy of the parliament, we have the rule of law, and we have the independence of judiciary. For this case, we are going to discuss one by one very briefly for everyone to take note of. So let's start with the doctrine of the separation of power, whereby we have Locke and Montesquieu, as we have seen them before. These are taken to be the forefathers of the modern democracy. We are told that they take the time to expound the doctrine of separation of powers. In as far as John Locke and Montesquieu are concerned, they are of the view that executive powers were concerned, and Locke contended that they are of 2 types so far as these executive powers are concerned. That there were executive power which is concerned with the execution of municipal laws, and federative power which was responsible for making war and peace. So this is according to John Locke and Montesquieu. Montesquieu, in another phase, he was of the view that in every state, there are kinds of powers: the legislative power, the power executing the matter falling within the law of nations, and the power executing the matter falling within the civil law. So we have seen I would say there are 2 different views here as between Montesquieu and John Locke when they discussed the different powers that can be found within the state organs. So we are told Montesquieu, when writings on the issue of executive powers, received a number of criticisms. One of the criticisms, it is said that he forgot on how big the executive powers could be seen. So despite several criticisms, Montesquieu succeeded in laying down the foundation for the modern doctrine of separation of powers. He is said to be the father of the modern separation of powers. We have another scholar who also discussed on this principle of separation of power, who is called Wadley. Wade is a very renowned English philosopher or constitutional lawyer who was of the view that separation of power, or the doctrine of separation of power, may mean three different things. One would be that the same person should not form part of more than one of the three organs of the government. That the minister should not sit in the parliament, or the judge should not sit in the parliament. So one person to remain in his or her position, make certain decisions, discharge certain duties without any kind of interference. Another issue, according to Wade, is that one organ of the government should not control or interfere with the work of the other organ. Another issue, that one organ of the government should not exercise the duties of the other organ. So these are the three important issues as put forward by Wade so far as this doctrine of separation of power is concerned. I would say a bit on the application of the doctrine, saying on the application of the doctrine of separation of power. It is generally known that the application of the doctrine of separation of power differs from one country to another. So I've pointed out few examples of the United Kingdom, as we have seen, in the United States of America. So these are just examples, but these differ from one country to another. Let's see another doctrine, another constitutional principle, which is the doctrine of parliament supremacy. I traced a bit of the history on parliamentary supremacy, whereby it is said that the history of the revivals between the king and the king, or the king council and the common law courts, and later the people's representative organs that led to the parliamentary supremacy. We have another scholar called Disse, who also discussed on this doctrine of parliamentary supremacy. It is the same as parliamentary sovereignty, and according to Disse, he tries to explain the omnipotence power that the parliament enjoys in the legislative process. So Disse tries to differentiate between the terminology sovereignty as opposed to supremacy. He was of the view that the concept of parliament sovereignty means the power of the lawmaking unrestricted by the legal limit. But again, legal sovereignty is not sovereignty at all, because courts will always recognize as last rules, which is the parliament makes the legislation. So for these reasons, there has grown a tendency of using the terminology supremacy instead of sovereignty. So as we have seen, what Disse was saying between the two terminology, the sovereignty and the supremacy, that is why we are using the terminology supremacy. According to Disse, supremacy of the parliament defines, at the end, I pointed out how Disse defined parliament supremacy. He was of the view that this is the right to make or unmake any law whatsoever, and further that no person or body is recognized by the law of England as having a right to override or set aside the legislation of the parliament. So according to Disse, this is the definition of parliamentary supremacy. Let's see another doctrine, another constitutional principle, which is the rule of law. we're told that, like any other doctrines, as we have seen them, or as we have previously discussed them, this also was formulated during the 18th century. This was formulated during the 18th century, as I've said, during the liberal democratic in Europe. The concept has been a principle of the Constitution since the Middle Ages. So it was there and continued to be there. Professor Dese is also talk of the principle of the rule of law. As I've said, this principle was developed during the Middle Age, and it possessed a higher authority, whether divine or natural, than that law made by human rulers, for example, kings. So this was the law that possessed a higher authority during the Middle Age. Indeed, we had another scholar called Cicero. Cicero was of the view that this law had a universal application, unchanging and everlasting. It summoned to duty by its commands and averted from wrongdoing by its prohibition. So this is according to these two scholars, Cicero and Dese. They are saying such superior law governed kings as well as subjects and set limits to the prerogative powers vested to the kings. We are talking of the rule of law principle. So it is said rule of law signifies the supremacy of the common law, including statutory and case law, as we are all aware that no one is above the law. Let's see another doctrine, another constitutional principle, which is independence of judiciary. We are told, like any other doctrine or any other principle, the independence of judiciary is also one of the fundamental constitutional principles. It was also formulated at the beginning of the 17th century. In this independence of judiciary, I will discuss briefly on the three issues. We have the security of tenure, we have the separation of judicial powers and personnel, we have the security of personnel emoluments, and last but not least, we have the judicial immunity from prosecution and litigation. So when we talk, let me discuss briefly on the issue of judicial immunity. It is well said that no judge or no action will lie against any judge or judicial officer for any word or act which has been said or done during his when he or she was at his judicial capacity in the court of justice. Also, we have the security of tenure. As we all know that the tenures for judges is well secured by the very, very specific laws. We have the separation of judicial powers and personnel from the executive and legislature. As I've said earlier, that from when we were discussing the principle of separation of power, that no one is supposed to interfere or exercise the work of another organ. So this is also one of the very important feature insofar as this doctrine of independence of judiciary is concerned. So this is all what we have for today.